Hi everyone, my name is Tuan.
And my name is Gerry.
And today we're going to talk about Chief Justice Roger B. Taney.
And the court case, the United States versus the New York Times.
First, I'm going to talk about Roger B. Taney's early life. Roger was born in March 1777 in Calvert County, Maryland. He came from a wealthy slave-owning family of tobacco farmers, and he's the second son out of 6 children. In 1806, Taney married Anne V. Charlton Key, who is the sister of Francis Scott Key, and together they have 6 children and a son who didn't survive through infancy. As a young boy, Roger attended village schools and learned classes from his private tutor. Because he is not going to inherit the Tenis property, he decided to pursue law at Dickinson College in Pennsylvania in 1792. On June 21, 1823, Andrew Jackson offered Taney to be the Attorney General. In June 1832, Taney advised Jackson by letter to veto the bill that rechartered the bank during the struggle of the Bank of the United States. Now I'm going to talk about Roger's presidential appointment. In 1835, Gabriel Duval retired as Associate Justice of the U.S. Supreme Court, and Jackson nominated Taney. But the Senate refused, even though Chief Justice John Marshall supported it. In the following year, 1836, the Supreme Court ratified his appointments as Chief Justice due to changes of the membership. And next, I'm going to talk about some of his landmark cases that he ruled on. First is Charles River Bridge case in 1837. In this case, Taney declared that any privileges of a private business must be granted or decided in favor of the state. Next, a Dred Scott case in 1857. Here he held that slaves, including descendants of slaves, were not citizens, therefore they might not sue the federal court, and Congress could not forbid slavery in the territories of the U.S.
Now I'm gonna talk about the court case that the New York Times versus the United States. In 1971, the New York Times illegally published a then secret document called the Pentagon Papers, which is about the detailed government deception only used in federal government with regard to the Vietnam War, as the federal government was trying to inhibit the New York Times by going to the court to make the New York Times to unpublish the Pentagon Papers. As a result, the New York Times countered the court by arguing that preventing publication would violate the First Amendment. However, the government claimed that publishing the secret federal document will put the national security in danger. Also, the First Amendment does not have fully freedom for publication. This idea was to counter the argument claimed by the New York Times about the guarantee of freedom of speech from the First Amendment. The per curiam opinion of the court was to grant certiorari in the case about the United States seeks to enjoin the New York Times from publishing the contents of a classified document entitled History of U.S. Decision-Making Process on Vietnam Policy, which led to the decision of preferring the New York Times by citing a prevailing precedent and sticking with the First Amendment about the absolution of freedom of speech. This was passed with a 6-3 decision, as the federal government could not prove that the publication of the Pentagon Papers would harm the national security.
That's all for our presentation.
Thank you for watching our presentation.